sale of land. 2. Reducing title to land. After the exchange of contract, the vendor is required to show that he has a good root of title and that he is in a position to transfer what he has contracted to convey and in the manner in which he discharges that duty. It is therefore important to know that the vendor is under a duty to deduce his title to the land after the contract has been exchanged. Other registration of instruments. This is obtainable in states operating the Conveyancing Act and the Property and Conveyancing Law. In these states, the instrument is registered and not the title itself. Thus, the title could be defective and cannot be cured by the mere act of registration, hence the need for the vendor to deduce his title. Limitation of years. A purchaser must insist that the title be deduced up to a certain number of years. B. In CST, it is 40 years. 40 years here is 40 years preceding the date of the present transaction. In Abia State, it is a period of 30 years. Section 70 sub 1 Abia State Law of Property. Very important, in Lagos, the right of an owner is extinguished after 12 years of adverse possession. However, it must first be established that the owner was dispossessed and the period of dispossession continued for the period of 12 years. Majeku Dumi and Abina 2002 3 Nigerian Weekly Law Report, Part 755. Generally, presumption of regularity is raised in favor of facts or statements contained in the recital of a document that is 20 years old. The person named in the document will not be allowed to deny the facts contained in the said recital of the document. Section 17 and 21 Limitation Law of Lagos State. Methods of deducing title. A vendor can deduce his title to land by the production of abstract or epitome of title. Both documents are simply the summary of evidence of the history and types of the title of the vendor. Abstract of title. An abstract of title is a written chronological summary of the history or account of how the property under consideration has moved from one person to another person, beginning with the root of title up to the present vendor who now wants to sell. In the past, when photocopying machines were not readily available, the abstract was typed on a brief paper divided into 6 columns as shown below. So he should satisfy himself that the abstract epitome of title has the following matters. 1. It commences with the goods of title. 2. That the parties mentioned in the transaction are power to buy or convey or otherwise deal with the property. 3. That there is no subsisting encumbrance except those that are disclosed in the contract. 4. That all the mortgages charged on the property have been duly discharged. And 5. That all documents have been duly registered, requisite consent obtained, stamped, and registered. Content of an abstract. A. Date of the document. B. Nature of the event. C. Parties to the transaction in the stated event. D. Whether or not the documents are certified true copies, photocopies, or originals. E. The number of documents. F. Whether or not the originals of the document are to be handed over on completion. Advantages of using abstract epitome of title. A. It provides at a glance the nature of the vendor's title. B. It helps the solicitors to make requisitions on the title. C. It assists the purchaser solicitor in preparing a search report on the title. And D. It provides a prima facie evidence of any defects in the vendor's title. However, it is worthy to know that this evidence is not a conclusive one. Disadvantages of abstract epitome of title. A. There are possibilities of making errors while preparing the abstract. B. Preparing abstract epitome of title takes a longer period of time than photocopying. C. Unnecessary time is spent examining the abstract against the originals. Origin of abstract epitome of title. Abstract originated as a result of difficulties in delivering documents and deeds of title to the purchaser for verification. The advent of photocopying and scanning machines have thus eliminated the use of abstracts. Requisitions of title. Requisitions simply means query. Having gone through the vendor's abstract epitome of title, it is expected that the purchaser should ask some questions where necessary. It is the purchaser's right to ask these questions. However, the questions should deal only on relevant and important matters which should not be disclosed by mere inspection of the property. Root of title. This is the foundation or source of title. It is the point at which the vendor's title commences. It is important for a vendor to be able to deduce a good root of title. Attributes of a good root of title. A. The document should sufficiently describe the property and the extent of interest sought to be conveyed. B. The document presented should transfer both the legal and equitable interest in the property. And C. The document should not contain chains and breaks in title. Examples of documents constituting good use of title are A. Deed of gift, B. Deed of assignment, C. Deed of legal mortgage, D. Certificate of title sequel to a purchase from the court, and E. Registered titles. Examples of documents constituting bad use of title are A. Lease, B. A will, C. A power of attorney, and D. Certificate of occupancy.